What's up, everybody? It's your favorite neighborhood lawyer, Marquel Cade with Cade Mark Law, back with another resource for you. I have so many clients that are in the military, whether they're from my hometown and they hit me up, or they're here in Colorado and they hit me up. A lot of them need powers of attorney. Well, today we're going to talk about 4 types of power of attorney. Before we even get into that, let's talk about what a power of attorney even is. A power of attorney is a legal document in which a principal, whoever is authorizing the power of attorney, designates an agent to act on their behalf. This document authorizes that agent to make limited decisions on behalf of that principal or broad decisions on behalf of that principal. So basically speaking, a power of attorney is a legal document that gives someone else authority to act on someone's behalf. The first type of power of attorney is a general power of attorney. A general power of attorney is also sometimes known as a conventional power of attorney or a limited power of attorney, but generally speaking, a general power of attorney starts when it's signed and continues in force until the principal becomes unable to make mentally coherent decisions. It's important to state exactly what this power of attorney gives the agent to do, and it can be very specific, like giving the agent authority to sign a deed simply while the principal is on a trip around the world, or it can be more general in that the agent has broad discretion over the principal's bank accounts. A general power of attorney is the most common type of power of attorney you will see. The second type of power of attorney is known as a durable power of attorney. A durable power of attorney begins when it's signed and stays in effect for a lifetime unless there's a cancellation. It's important to remember that for durable power of attorneys, there will be some language in the document that specifies that the agent's power stays in effect even if the principal becomes incapacitated. This is important language to look for because this is the language that creates a durable power of attorney. Durable power of attorneys are popular, and they're very popular because they're inexpensive and make managing affairs easy. However, be very wary of issuing a durable power of attorney because unless you cancel it, it's in effect for a lifetime, which means there's someone else who can make decisions on your behalf for the rest of your life, even when you're unable to make those decisions yourself. The third type of power of attorney is known as a springing power of attorney. A springing power of attorney comes into effect when a specific event occurs. In this instance, it can be when someone turns 18, when someone turns 65 and can no longer manage their affairs because of some mental illness or some disease. A springing power of attorney must be very carefully crafted to avoid any problems in identifying what that triggering event is. And usually you can tell that there is a springing power of attorney by the mention of an agent gaining power upon some happening of that specific triggering event. I most often see springing power of attorneys in cases of deployment when a soldier knows that the date that they're coming back will be a certain date that they want the agent's authority to end. I've also seen them in instances of elder incapacity when there's a disease like dementia that allows for a specific event to occur that the individual cannot make decisions on their own any longer, and there needs to be an agent making those decisions for them. The fourth type of power of attorney is a mixture of a durable power of attorney and a springing power of attorney. It's known as a medical power of attorney or a durable power of attorney for healthcare decisions, or a healthcare proxy sometimes. The springing aspect of this power of attorney takes effect if certain medical conditions take place. As long as the principal is conscious and of sound mind and body, the medical power of attorney will not be triggered. But if some medical event occurs that leaves the principal incapacitated due to a medical emergency, some medical power of attorneys are written such that the agent's authority starts at that point. Some medical power of attorneys are written to end when the principal recovers from the incapacitating condition, and there are different conditions that you can put in your own medical power of attorney that can specify when the principal gains their authority back. Generally speaking, a medical power of attorney is good for almost everyone to have. In the event that you become incapacitated or some medical event leaves you unable to make your own decisions, you want some guiding authority or someone you trust making those decisions on your behalf as you would. I think medical power of attorneys are perhaps the most flexible and the most widely used and available for everyone in every situation, not just my soldiers that come to me and need power of attorneys. That's all, folks. Thank you so much for joining us today. This has been 4 Types of Power of Attorneys. Once again, I am Markwell Cade with Cade Mark Law, your favorite neighborhood lawyer. Protect your brand, grow your business, stay frosty, my friends. We will see you next time. We hope this was helpful.